Hello dear viewers, welcome back. This is Induslex Academy and today we are going to discuss Indian Evidence Act. Dear friends, whether the proceeding is civil or a criminal, the law applies regarding the evidence is that Indian Evidence Act, which is further repealed by the Bhartiya Shakshya Adhiniyam 2023. Bhartiya Shakshya Adhiniyam 2023, dear friends, it applies to all judicial proceeding in or before court, including court martial, but not to the affidavits presented to any court or officer, nor to the proceedings before an arbitrator. It is enforced from July 1, 2024. Section 2 of Bhartiya Shakshya Adhiniyam 2023 is a type of definition or interpretation clause in which Section 2 Clause A defines word court. What does court means? Whether we are discussing it with the meaning of basketball court or a tennis court? No. Here the section says the court includes all judges and magistrate, meaning thereby where judges or magistrates sit, that is the court. Section 2 subclause A defines court includes all judges and magistrate and all persons except arbitrator legally authorized to take evidence, meaning thereby any person, whether he is magistrate or a judge, if he is legally authorized to take evidence in a particular proceeding, that is called court. And in that court, arbitrator is not come in the ambit of the definition of the court. Now section 2 subsection clause B defines conclusive proof. What is a conclusive proof? Section says means when one fact is declared by this Adhiniyam to be conclusive proof of another, the court shall on proof of one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Meaning thereby, if in this Adhiniyam, if particular fact is given and that fact is proved by any piece of evidence which is relevant or admissible under the Evidence Act or this Bhartiya Shakshya Adhiniyam Act, and if that fact is a conclusive proof of another fact, then court will not allow any person to give any evidence to prove that another fact or to disprove that another fact, because in this Adhiniyam it is held that if the particular fact is proved and it is a conclusive proof of another fact, then the opposite party is not allowed to produce evidences for disproving that fact. This is called conclusive proof. Bayer Act says conclusive proof means when one fact is declared by this Adhiniyam to be a conclusive proof of another, the court shall on proof of one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Now section 2 clause C disproved in relation to a fact means when, after considering the matters before it, court either believes that it doesn't exist or consider its non-existence so probable that prudent man ought, under the circumstances of the particular case, to act upon supposition that it does not exist. What is disproved means? Disproved means if the court believes that this particular fact would not be possible, or in the ordinary course a prudent man under the particular fact and circumstances of case believes that it doesn't exist. Further, Section 2, clause D defines document. What is document? Documents mean any matter expressed or described or otherwise recorded upon any substance by means of letters, figures, or marks, or any other means, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter, and includes electronic and digital records. What the section says, it says that if anything is prescribed upon, if anything by way of letter, figure, or marks is expressed or described on any material or recorded in any form, that is all called the documents. Suppose A writing is a document. Words printed, lithographed, or photographed are documents. A map or a plan is a document. An inscription on a metal plate or stone is a document. A caricature is a document. An electronic record on email server logs documents on computer, laptop, or smartphone, messages, website, location evidence, voicemail message stored on digital devices are documents. Now section 2E, a very relevant provision. It defines evidence. What evidence means? Section says evidence means and includes all statements given electronically which the court permits and required to be made before it by witnesses in relation to matter of fact under inquiry, and such statements are called oral evidence. All documents including electronic or digital record produced for the inspection of the court, and such documents are called documentary evidence. Evidence may be given in two forms, whether it is oral evidence or it is documentary evidence. And further, this section gives scope to place electronic records in a form of evidence in the court proceeding. Now section 2F defines fact. Again, fact means and includes anything, state of things, or relation of thing capable of being perceived by the senses. Means anything which can be perceived by the senses is called fact. Includes any mental condition of which any person is conscious, that is also a fact. Suppose that there are a certain object arranged in a certain order in a certain place is a fact. Person heard or saw something is a fact. A person said certain words is a fact. That a person holds a certain opinion, has a certain intention, act in good faith or fraudulently, or uses a particular word in a particular sense, or was at a specified time of conscious of particular sensation is a fact. Now when we talk about the fact defined in section 2F, 2G is more relevant because it defines fact in issue. Whenever a court proceeding starts, the major question is that in the particular proceeding which is before the court is what is the fact in issue, on what fact in issue means and include any fact from which either by itself or in connection with other facts, the existence, non-existence, nature, or any extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. Means it is a core issue upon which court is going to be adjudicate. That is the fact in issue. Meaning thereby there are several facts, may be relevant, irrelevant, admissible or inadmissible, that all are facts, but fact in issue is the major legal question before the court upon which the court has to adjudicate. Suppose that A is accused of the murder of B. At this trial, the following facts may be in issue: that A caused B's death is a fact in issue. That A intends to cause B's death, again fact in issue. That A had received grave and sudden provocation from B. That A at the time of doing the act which B caused B's death was by reason of unsoundness of mind incapable of knowing its nature. Now section 2H define may presume. When court may presume a particular fact, whenever it is provided by this Adhiniyam that court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. The act says that when there is anything provided in this Adhiniyam that court may presume a particular type of a fact, it may either regard that the court may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Suppose that if there is a certain facts upon which court believes that it may be possible, then court may presume that this fact is proved, or maybe court may inquire to call for proof of that particular fact, or believe that it is approved until it is disapproved by the opposite party. What is not proved? It defines in section 2I. A fact is said to be not proved when it is neither proved or nor disproved. If a particular fact is not disproved by anyone, and if that particular fact is actually not proved by anyone, it is called not proved. And what is proved? Defined in section 2J. A fact is said to be proved when, after considering the matters before it, court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon supposition that it exists. Proved means a particular fact is said to be proved. We can say that the particular fact is proved when, after considering the matter before it, the particular court either believe it exists or considered its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it particular fact is existing. Now section 2K, relevant. A fact is said to be relevant to another when it is connected with the other in any way referred to in the provision of this Adhiniyam relating to the relevancy of fact. A fact is to be relevant when there are several provisions continuously is given in this Adhiniyam, and if a fact come into the ambit of any particular section regarding the relevancy of facts, then we can say that that fact is relevant. Now section 2L, shall presume. Whenever it is directed by this Adhiniyam that the court shall presume a fact, it shall regard such fact as proved unless until it is disproved. Here it is meaning that if in the Adhiniyam, if the court shall presume a fact, it shall regard such fact as proved when a particular fact is directed by this Adhiniyam to the court, that court will presume and shall presume, then court believes that it is a proved fact, and unless and until it is disproved by the opposite party. However, when we read the conclusive proof, there the court will bound to presume that the particular fact is a conclusive proof of another fact. If one fact is proved, then definitely another fact is conclusive proof of that fact, and therefore court will not allow to disprove or taking evidence, giving evidence by the opposite party to disprove the other fact, because if one fact is proved and that fact is a conclusive proof of another fact, then it is not permissible to the opposite party in that regard to give any type of evidence to disprove that fact. Now, section 2, subsection 2 says word and expression are used herein and not defined but defined in the Information of Technology Act 2000, Bhartiya Nagrik Suraksha Sanhita 2023 and the Bhartiya Nyaya Sanhita 2023 shall have the same meaning as assigned to them in the said acts and Sanhita. What it says? It says that, see, there are certain definition given in section 2 subsection 1 to L, and there are many others words are going to be used in this act, and that is not defined in section 2, but they have the same meaning which are given in the Information and Technology Act or Bhartiya Nagrik Suraksha Sanhita, Bhartiya Nyaya Sanhita. Now the expression proved, disproved and not proved. It is a very important and fundamental question. When a fact is proved or disproved, or we can say it is not proved, these expression lays down the standard of proof, namely about existence or a non-existence of circumstances from the point of view of a prudent man. So much so that while adopting the said requirement, an appropriate concrete standard to measure proof, full effect has to be given to the circumstances or a condition of probability or improbability. The expression fact, not only the physical act which can be perceived by the senses, but also the psychological fact or a mental condition of which any person is conscious, and that is in the former sense that the word used by the legislature refers to a material, not to a mental fact. Presumption. Presumption means taking as a true without examination of proof. It is by which the courts are enabled and entitled to pronounce on an issue notwithstanding that there is no evidence or sufficient evidence. Presumption when may not be invoked, when truth of fact is known and there is no need or any room of any presumption, when there is a conflict between a conclusive proof envisaged under law based on presumption and a proof based on scientific advancement accepted by the world community to be correct, the latter must prevail over the former. Rebuttable presumption. Presumption when rebuttable. Presumption when rebuttable points out the party on whom lies the duty of going forward with the evidence on the facts presumed, and when that party produced the evidence tending to show that the real fact is not as presumed, the purpose of presumption is over. Now the conclusive proof, when act enjoins that any evidence would be treated as a conclusive proof of certain factual situation or legal hypothesis, law would forbid other evidence to be adduced for the purpose contradicting or varying such conclusiveness. Thank you.